So, Ioana, what is the status of Ontario's privacy legislation at this time? And what do organizations need to turn their minds to when it comes to privacy legislation in Ontario?
Well, Seth, you said it. Limbo is the word. It's been a long time coming and we're still waiting. But employers in Ontario need to turn their minds to how new privacy legislation coming down the road may impact their operations. Currently, the default in Ontario is that the federal legislation, PIPEDA, applies to broader personal information collected in the course of commercial activities. But this does not apply to how employers collect and use employee personal information. However, we've seen what can happen when new privacy legislation is enacted in other provinces. When other jurisdictions enacted substantially similar legislation to the federal PIPEDA, that new legislation ousted an employer's obligations under the federal regime and replaced those obligations with more comprehensive ones from the province. For example, in BC, organizations must now consider not only information collected from customers and clients, but also personal information collected about their own employees. This can range from job applications, references, performance evaluations, to termination letters. Employers in BC must also notify employees in advance about the information they are collecting about them and why. When similar changes are likely to happen in Ontario, we know they will likely create additional constraints for employers. These constraints could include increased transparency with how employers use employee information, improved clearer consent provisions, an individual's right to request deletion of personal information, and the use of de-identified data. So in short, employers should familiarize themselves with their existing practices regarding both employee and customer and client personal information so they can hit the ground running when it comes to having to make changes.